Okay, let's begin the podcast. We are going to be talking about your introductory pharmacy practice experiences, and this law briefing is meant to get you started with your IPPEs and is a bridge before you take your more formal law course at the beginning of the third year. We're going to begin with a background and purpose for pharmacy laws, and then we're going to lead into some major definitions and their meanings that you have to get under your belt before you begin practicing pharmacy. So today we're going to start talking about how pharmacy law is structured, and not really about what any of the laws are themselves until later. This is a chance to talk about the forest. So when we start talking about the trees, you can see where each of the trees fits into the forest. In other words, it's kind of hard to understand sometimes because you're looking at all this stuff and you just can't figure out where it fits in. The way to begin this is a way that may insult your intelligence a little bit. I hope I'm not too bad about doing this because we need to start over again with 9th grade civics or social studies. And I know most of you paid a lot of attention in 9th grade civics, but maybe some of you didn't, and to some extent many of you may have forgotten a little bit of it. Well, essentially there are 3 branches of government. Yep, it's as basic as that. 3 branches of government. The branches of government are the judicial branch, the legislative branch, and the executive branch. So that is kind of the type of way we're going to visualize this forest in order to understand the trees within the forest. The judicial branch is the branch we probably won't have a whole lot to do with in this course, where we are just looking at the rules. The judicial branch is courts of law, where judges decide controversies between people who have brought lawsuits against each other. In doing that, courts serve a very important role because they make new law through judicial opinions that they write, and they also interpret existing law. So to the extent that the executive branch or the legislative branch has made law, courts, the judicial branch, serves an important role in interpreting that law. But our focus will not so much be on the judicial branch, at least in this course. In this course, we are going to focus on the legislative branch and the executive branch. First, let's talk about the legislative branch. We have a legislative branch at the state level and at the federal level. The legislative branch is composed of elected people for whom we vote and who we send either to Albany for the state legislative branch or to Washington, D.C. for the federal legislative branch. In the state of New York, we have a Senate and an Assembly. In the federal government system, we have the United States Senate and the United States House of Representatives. And these are all the people who are not specialists in what they do, as you know. They are politicians. They are not people who necessarily take a great deal of time studying a specific area that they would regulate, like pharmacy law, for example. We have very rarely anyone in the United States Congress who is actually experienced in pharmacy and knows that area very well. A lot of lawyers, a lot of business people, salespeople end up as becoming politicians, and they go to Washington, D.C., and what they do is enact statutes. Now this is important. A statute is something that a legislative body has enacted, usually in the state and in the federal government. Both the House and the Senate on the federal level have to agree on a piece of legislation before it becomes a law. Now, a piece of legislation, a statute from the legislative branch on the government, is broad, it's general. It lacks specificity that one might expect from people who are really experts in this specific field. Rather, a statute is a broad general piece of legislature that is enabling in nature. It makes it possible for someone else to regulate. The key word here is enabling. It might create another body of people legislatively authorized to do more than the legislature does. The state legislature only meets a few months of the year. United States Congress is full-time, working at all times. Well, not in session at all times, but there. Sometimes they go back to the area they represent and try to find out what needs to be done back in Washington, D.C. to help the people whom they represent, so they are full-time. The state-level senators and assemblymen are not full-time people, so they really can't be expected to be enforcing the law all the time. Rather, they establish a broad general framework. They set policy within which people accomplish what needs to be done. Now, who is it then that on a day-to-day basis enforces the law? Well, this is the executive branch. The executive branch is most visible to people who read newspapers and watch television in the form of the chief executive. On the state level, the chief executive is the governor. On the federal level, however, the chief executive is the President of the United States. Now, there are many other people who are elected also, like the United States Attorney General, for example. The Attorney General of New York, and these people are part of the executive branch. They have very important roles to play as well, but they are not really very many of those people, and they rely to a significant degree on administrative agencies. Administrative agencies are a kind of a new creation. I'm not sure that the people who wrote the Constitution 200 years ago had any idea that administrative agencies would become as powerful and influential as they have. Administrative agencies are composed of people who are either appointed by the chief executive and who are consented to by the legislative branch. And these people are somewhat political, of course, because they are appointees of a person who is elected. They are not as political as people who are actually elected, but they are political to a degree. Administrative agencies are also staffed by lifetime public servants who make a career working for the government. And these people are not political. Again, they are not as political as the people who are actually elected, but they are political to a degree. Administrative agencies are also staffed by lifetime public servants who make a career working for the government, and these people are not political at all. In fact, the law requires that they be protected from changes in government by political people, so that if a new politician comes into power, then in theory at least people who are lifetime public servants have job security and give continuity to an administrative agency. So folks in administrative agencies like the State Board of Pharmacy are around quite for long periods of time. Administrative agencies tend to consist of people who have expertise with the field they are regulating. So as opposed to the legislative branch that makes statutes that are broad, general, and enabling but lack specificity, because the people who make them don't really have the expertise that is required to be specific. Administrative agencies do make specific rules. They promulgate rules and regulations, and these rules or regulations expand on the broad general character of statutes that are enacted by legislatures. So the legislature, the elected people who are political, enact statutes that are broad and general. The administrative agencies, appointed people or career servants, promulgate rules that are specific. They expand on the broad generalities that are encompassed within the statutes that the legislature enacts. Now let's go back for a minute to administrative agencies at the federal level. These specific rules or regulations prescribe in pharmacy law exactly what is expected of pharmacists and people who distribute pharmaceutical products. There are some important examples for us of statutes that have an impact on pharmacy practice. At the federal level, probably the two most significant statutes are the Food, Drug, and Cosmetic Act and the Controlled Substances Act. So those are the statutes that are enacted by Congress that provide broad, general rules for which administrative agencies conduct their business. The administrative agency that is authorized to act under the Food, Drug, and Cosmetic Act is the Food and Drug Administration. And the administrative agency that is authorized to act under the Controlled Substances Act is the Drug Enforcement Administration. These are very different agencies. The Food and Drug Administration is oriented toward public health. Most of the people who work for the Food and Drug Administration have some sort of healthcare background, and their goal is to make the nation's drug supply for medicinal purposes as safe and as effective as it could possibly be. So their focus is on health. However, the Drug Enforcement Administration is very different. Most of the people who work for the Drug Enforcement Administration have some sort of police enforcement background. They are not healthcare professionals. In fact, very few people for the DEA have any sort of healthcare background at all. Rather, their concern is to prevent certain chemical substances from being abused and from causing social problems and drug abuse social problems that drug abuse produces. So these two agencies, although they work together, have very different functions. Now let's look at the history of some important federal laws related to pharmacy. And these laws all become part of what is called the Code of Federal Regulations. So if you talk to people about the law, they often refer to the CFR. So let's just go briefly through a history of the laws that serve as a basis of food and drug law in the United States of America. What I'm talking about are the laws that regulate all medications, whether they are controlled substances or not, anything that is used as a medicinal drug. The first federal law is the Pure Food and Drug Act of 1906. The purpose of the Pure Food and Drug Act of 1906 was truth in labeling. It established for the first time this idea of misbranding. That is, the idea that a person who puts on the market a drug product could place on that product a statement that is false and would cause harm to the public. So the Pure Food and Drug Act of 1906 says, to the extent you put anything on the label, what you put on the label must be true. Now, it didn't say you didn't have to put anything on the label and that it was a problem with the Pure Food and Drug Act of 1906, because all the manufacturers and any other distributors of drugs had to do is just not put anything on the label. And since they didn't put anything on the label, people could purchase the product and still be uninformed about it, because there was no affirmative disclosure requirements in the 1906 law. In 1938, however, the Food, Drug, and Cosmetic Act came along. It's the law that we currently have in force as amended, and we'll talk about amendments to it. So this law has lasted for many, many years without needing to be completely redone. The Food, Drug, and Cosmetic Act introduced a number of concepts, foremost of which was the idea that in 1938 drugs should be approved prior to their being put on the market, or more specifically, new drugs should be approved before they can be put on the market. Drugs that are not generally recognized as safe and effective. Now, they grandfathered in all drugs that had been marketed prior to that time. So pre-1938, drugs, and there still are some on the market today, have not necessarily been approved by the FDA, because they do not need to be so, because they were grandfathered in by provisions of the Food, Drug, and Cosmetic Act of 1938. But what the law said was that before you can go on the market with a new drug, one that is not generally recognized as safe and effective, you have it approved for safety to make sure that the drug is safe for purposes for which it is intended. The next important statute that was enacted by Congress was the Durham-Humphrey Amendment of 1951. It became effective in 1952, and this is particularly important for pharmacists because the main thing that this amendment did to the Food, Drug, and Cosmetic Act was to establish two classes of drugs: prescription only and over-the-counter drugs. It recognized the possibility that there are some drugs that cannot be used safely. It is impossible to label them safely for use without medical supervision, and it is authorized by placing on the label of those drugs caution: federal law prohibits dispensing without a prescription. Now, what that did, of course, was remove from pharmacists the authority over the distribution of those drugs, the decision-making authority, and gave the physicians the authority to decide what patient received them. What pharmacists did get was a monopoly over the order processing of prescriptions, but they gave away the judgmental task of deciding whether or not patients should receive a medication. After that, the 1962 Kefauver-Harris Amendment was enacted in order to add to the safety requirements for pre-market study and efficacy requirement. In essence, what this requirement said is that not only must a manufacturer or a new drug show that their product is safe, that manufacturer must also show the product is effective prior to its being marketed. Now, in 1984, the Drug Price Competition and Patent Restoration Act was passed. What that law does is make it easier for some generic drugs to get on the market. Now, generic drug products that previously would have not been able to get on the market, this would allow them to be approved through an abbreviated new drug application. It also extends the patent time that is allowed to the innovator manufacturer that has used a new drug application to get their product on the market. So it was a kind of trade-off that on the one hand a benefit to generic manufacturers, and on the other hand a benefit to trade name manufacturers. A more recent important modification to the Food, Drug, and Cosmetic Act of 1938 was the Prescription Drug Marketing Act of 1987. That enactment by the United States Congress, by the legislature in the House of Representatives, was intended to address problems of diversion of pharmaceuticals. Evidently, what was happening was some people were acquiring pharmaceuticals at huge discounts or through some other mechanisms, and were diverting those from the legitimate chain of distribution outside of the chain for a period of time, only to have them reappear again within the chain of distribution at some point, and eventually being dispensed to patients. Some of those drugs were sample drugs. Some of those were just bought at preferential prices. The problem was that during the period of time when the drugs were outside the normal chain of distribution, the standards of quality that apply to drugs within the chain weren't necessarily being observed, so the product integrity was a real question at the time. And to assure that products remain of good integrity, that the quality of the pharmaceutical products in the United States was not threatened, the Prescription Drug Marketing Act of 1987 was passed. Now, before we finish with this section, I'd like to address two things very briefly. Concerning the Controlled Substances Act of 1970, you should keep in mind that many of the drugs included within this title have a useful and legitimate medical purpose and are necessary to maintain the health and general welfare of the public. That's very important to remember because I said the Drug Enforcement Administration is not particularly oriented toward health care. They are police people whose job is to enforce the letter of the law. And what the government has said is, well, that's fine, and we are going to enable you to do that and provide some specifics for you in your doing of it, but don't forget there are some legitimate medical uses for these medications. We must not lose sight of three facts. First, that psychotropic substances should not be unduly restricted to manufacturers, distributors, dispensers, and research should not be unduly restricted to just manufacturers, distributors, dispensers, and researchers for useful and legitimate medical and scientific purposes. Secondly, not interfering with bona fide research activities. And thirdly, not interference with ethical medical practice in this country. So it is important to remember that as fearsome as these controlled substance laws seem to be, as harsh as they seem to be, as restrictive as they seem to be, the government has said we do not want these restrictions on the distribution of controlled substances to interfere with the legitimate medicine. It is very appropriate for physicians in the United States to prescribe narcotic analgesics for people, for example, to treat pain. Pain is a condition that is deserving of treatment, and sometimes people who treat pain by either prescribing drugs by dispensing drugs that are deterred from treating pain effectively because they feel that controlled substance laws provide a regulatory barrier to their being, that because there are so many restrictions. The government has said, let us not be that way. Let's make sure that we have no interference with ethical medical practice so that, for example, patients who need narcotic analgesics get the drug that they need. The last thing that I want to mention is from the New York Pharmacy Acts, it finds the practice of pharmacy is a learned profession. The sole legislative purpose for enacting the law is to ensure that every pharmacist practicing in the state of New York and every pharmacy meeting minimum requirements for safe practice. So their job is to oversee the practice of pharmacy by individuals and the business of pharmacy by people who run pharmacy businesses. The legislative intent that pharmacists who fall below minimum competency or who otherwise present a danger to the public shall be prohibited from practicing in the state of New York. So what the legislature is telling the people who enforce this law, the State Board of Pharmacy, is that their responsibility through the laws they have been given from the legislature is to assure competency of pharmacists and assure that an appropriate environment exists within a pharmacy for competent pharmacy practice to occur. Now, one of the things I want to talk to you about is the state law, but before I want to go to that, I want to talk about how the state law and the federal law kind of interface. The federal government, though, is granted by the authority under the Constitution to regulate interstate commerce between states. It used to be that commerce between the states didn't occur very often when we had our colonial America that was just becoming a nation. Most things that happened within a state rather than between the states, and it is unusual to trade from one state to another. Now, of course, that's commonplace. Just about everything that happens is interstate rather than intrastate. What that means is the federal regulation under the Commerce Clause, the federal authority to regulate interstate commerce, impacts on virtually every intrastate transaction. And it has been held in case law, for example, the case of United States versus Sullivan, that the dispensing of medication by a pharmacist to a patient within a state is a transaction that is part of interstate commerce, because almost invariably the pharmaceuticals that are used by a pharmacist in that transaction came to the pharmacist across the state line. So here we have two conflicting sources of law. We have the federal government regulating the drug product and the state government regulating the people who prescribe and dispense and administer the drug product. That raises the potential for there to be a conflict where federal law says to do this and the state law says do that. As a general matter, when there is a conflict, a person has to follow whatever is the more strict law. For example, we might have a federal law that says ephedrine is available for purchase without a prescription, that no prescription is required. And yet we might have a state law that says, well, no, in this state we require that pharmacists and others sell this drug only if there is a prescription. What you would have to follow is the more strict of the two laws, both of which are applicable, and that would mean you could not sell ephedrine without a prescription. There are some exceptions to that and some nuances to it, but as a general rule, a person, such as a pharmacist, who is trying to comply with both state and federal law, has to follow whichever law is most strict. So let's move now from looking at federal law to state law. Now, in the state of New York, when we're talking about administrative agencies, we're talking about the State Board of Education. Those are the folks that, and under the State Board of Education is the Office of Professions. It's very important that you understand that. Now, within the Board of Education, there is the Board of Regents, kind of like what we have here for the governance of DUville College. The Board of Regents, on the recommendation of the Commissioner of Education, appoints a state board for each licensed profession to advise and assist the Board of Regents and the State Education Department on matters of professional regulation. The Board of Regents also appoints a committee for professional assistants to advise them on matters relating to practice by professional licensees who with alcohol or other drug abuse problems. The 29 state boards for the professions and the Committee for Professional Assistants are comprised of professional members and one or more representatives of the general public. So again, they're asking not only for these boards like the Board of Pharmacy to be composed of people that are pharmacists, both from hospital practice and from community practice, but that you also have a member of the general public to try to keep things honest. It's like here at the DUville College School of Pharmacy, we try to have students on our committees. It's the same reasoning. The composition of each board and the committee is specified in Title 8 of Education Law. In addition, board and committee composition should reflect the state's regions, cultural diversity, and various aspects of the profession. So again, when you're looking at the State Board of Pharmacy and they have like hospital pharmacists on the board, they will have a hospital pharmacist, well, they'll try to have a hospital pharmacist like from downstate and from upstate. Now let's switch to part 2, where we concentrate more on definitions and their meanings. But before I go that, I wanted to introduce you to this New York State Board of Pharmacy website. When you go to the New York State Department of Education .gov, you can find the New York State Board of Pharmacy, or you can just Google it. This is what the website looks like. For this particular podcast, we're going to concentrate more on the blue arrow. So if you click on where that blue arrow is, it says laws, rules, and regulations. We're going to concentrate on that for this podcast and the next podcast. And as you're on your IPPEs, I'm sure you'll have to take a look at, click on the green podcast, the green arrow, and look at that, the Pharmacy Guide to Practice, and we'll revisit that with 2 podcasts when you get back from your IPPs. So again, if you clicked on the blue arrow there, it would take you over to this screen. Now for this particular screen, there are 1, 2, 3, 4, 5 arrows, and we're going to begin with the first arrow here. We're under education law in the state of New York, and more specifically Article 137. That's very important for pharmacists in the state of New York, Article 137. And if you click on Article 137, the first thing that comes up is definitions. Now this may seem bland, it may seem difficult that you have to read these and you have to memorize them, but we really need to go through these because each word is very important. The first being the definition of the practice of pharmacy. And you need to know this, the practice of the profession of pharmacy is defined as the administering, preparing, compounding, preserving, or the dispensing of drugs, medicines, and therapeutic devices on the basis of prescriptions or other legal authority. Now this recently changed to add those few words at the end, or other legal authority. And whether or not those last four words appear after March 31st, 2010 depends on the legislature. That may revert, but for now, or other legal authority does exist. Now let's get into this. What that means is, for now, for like the next 2 years, a licensed pharmacist may execute a non-patient specific regime prescribed or ordered by a licensed physician or certified nurse practitioner pursuant to the rules and regulations promulgated by the Commissioner. When a licensed pharmacist administers an immunization, he or she shall report such administration to the patient's attending primary health care practitioner or practitioners, if any, pursuant to the rules and regulations of the Commissioner. Provide information to the patient on the importance of having a primary health care practitioner developed by the Commissioner of Health, and report such administration absent of any individually identifiable health information to the Department of Health in a manner required by the Commissioner of Health. All that is saying is you can have a collaborative practice agreement with a licensed practitioner or certified nurse practitioner to give certain immunizations in this state until March 31st, 2010, when the legislature will decide whether or not to continue this. There is a sunset provision on all this. So, for example, I have a non-specific collaborative practice agreement with Dr. Judelson, and I can administer certain medications like influenza vaccines and pneumococcal vaccines, and he has specified in 3 orders what I can do, non-specific orders. So any patient that comes to me, I can do this as specified by Dr. Judelson, and I have to record those online, and we will talk about those. No pharmacist shall administer immunizing agents without receiving training satisfactory to the Commissioner and to the Commissioner of Health, which shall include but not be limited to techniques for screening individuals and obtaining informed consent, techniques of administration, indications, precautions, and contraindications in the use of agents or agents, record keeping of immunization and information, and handling emergencies, including anaphylaxis and needle sticks. So later on, probably in your 3rd year, you will get this training to give immunizations, and at that time you'll learn about all of these things. You'll learn how to keep like diphenhydramine injection nearby for anaphylaxis and so on. The Commissioner of Health, in consultation with the Commissioner, shall prepare and submit a report to the Governor and the Legislature on or before December 31st, 2011, reporting the results and evaluating the effectiveness and impact of any of the implementation of this. And they'll decide whether to keep all of this in. Now, here are several different definitions that you need to know. There will be an IRAD covering these on Tuesday, but you need to know these. Pharmacy means any place other than a registered store in which drugs, prescriptions, or poisons are possessed for the purpose of compounding, preserving, dispensing, or retailing, or which drugs, prescriptions, or poisons are compounded, preserved, dispensed, or retailed, or in which such drugs, prescriptions, or poisons are by advertising or otherwise offered for sale by retail. Repeal just means there was something there that was taken out. I should actually have taken that out. Formulary means the latest edition of the official national formulary and its supplement. Pharmacopoeia, when not otherwise limited, means the latest edition of the official United States Pharmacopoeia and its supplement. Homeopathic Pharmacopoeia means the official homeopathic Pharmacopoeia of the United States and its supplement, and the official compendium means the official United States Pharmacopoeia, official homeopathic Pharmacopoeia of the United States, official national formulary, or their supplements. Now, I really won't go into the different volumes here that they're talking about. This is something that you'll actually get with your compounding and probably your basic sciences courses. But there are books like the Pharmacopoeia, the Homeopathic Pharmacopoeia, and so on that you'll learn in those courses. Drug. This is very important. Articles recognized in the official United States Pharmacopoeia, official homeopathic pharmacopoeia of the United States, and official national formulary. They are articles, and this is extremely important, articles intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease in man or animals. Articles other than food intended to affect the structure or any function of the body of man or animals. Articles intended for use as a component of any article specified in paragraphs A, B, or C, but does not include devices or their components, parts, or accessories. That is incredibly important to know, and I would advise you to know that by heart, because that will show up, for example, in the NABPLEX and the MPJE, both. Cosmetic means articles intended to be rubbed, poured, sprinkled, or sprayed on, introduced into, or otherwise applied to the human body for cleansing, beautifying, promoting attractiveness, or altering the appearance. Articles intended for use as a component of any such articles except the term shall not include soap. Poison, where not otherwise limited, means any drug, chemical, or preparation likely to be destructive to adult human life in any quantity of 6 grains or less. Label means a display of written, printed, or pictorial matter upon the immediate container of any drug, device, or cosmetic. Any requirement made by or under authority of this article that any word, statement, or other information appear on the label shall not be considered to be complied with unless such word, statement, or other information also appears on the outside container or wrapper, if there be any, of the retail package of such drug, device, or cosmetic, or is easily legible through the outside container or wrapper. The immediate container does not include package liners. And finally, labeling means all labels or other written, printed, or pictorial matter upon any drug, device, or cosmetic, or any of its containers or wrappers, or accompanying such drug, device, or cosmetic. So to me, what that means is the difference between a label and labeling. Basically, if you're talking about a label, you're talking about a label that sticks to the immediate container like a vial. When you're talking about label, you're talking about something that is handed to the patient in addition to the vial with a label on it. So, for example, drug information like a pamphlet or a videotape or something like that would be considered labeling, not label. Now, again, we had talked about the acts earlier when we talked about the Food, Drug, and Cosmetic Act and misbranding. This is, again, an important definition that you need to know what misbranding is. If a drug, device, or cosmetic is alleged to be misbranded because of labeling, the labeling is misleading, or if an advertisement is alleged to be false because it is misleading, then in determining whether the labeling or advertisement is misleading, there shall be taken into account, among other things, not only representations made or suggested by statement, word, design, device, sound, or any combination thereof, but also the extent to which the labeling fails to reveal facts material in the light of such representations, or material with respect to consequences which may result from the use of the drug, device, or cosmetic to which the labeling or the advertisement relates under the conditions of use prescribed in the labeling or advertising thereof, or under such conditions of use as are customary or usual. That is, no drug, device, or cosmetic which is subject to and complies with the regulations promulgated under the provisions of the Federal Food, Drug, and Cosmetic Act relating to adulteration and misbranding shall be deemed to be adulterated or misbranded in violation of the provisions of this article because of its failure to comply with the board's regulations or the rules of the State Board of Pharmacy insofar as the regulations are in conflict with regulations relating to the adulteration or misbranding under the Food, Drug, and Cosmetic Act. Boy, that's a mouthful. Now, I am not, this is a long statement that again is taken out of the Education Law Article 137, but I think probably what's wrong with this statement is that it really isn't emphasizing the difference between misbranding and adulteration. The meaning of adulteration doesn't come through or doesn't bleed through on this paragraph. Adulteration is like, I guess when you think of adulteration, the first thing that comes to my mind is when I think of adulteration, I think of a unclean factory where there might be rats that are depositing fecal matter or something into the devices, and or an infection of some kind of organism that gets into the tablets. That's adulteration. You're talking about putrid matter that gets in and causes problems with the drug. That's adulteration, or and it should be kept in mind that that is different than misbranding. So misbranding is when you say you misrepresent what is actually in that bottle, or at least what you think is in that bottle, by saying that it has something or it doesn't have something in there that you say it has. Misbranding and adulteration, I guess, where the conflict or the confusion occurs is when you have something in there like an organism or fecal matter and it isn't labeled there. So, but it's almost like a Venn diagram where you have misbranding and adulteration, and in some cases they overlap. But try to keep the distinction between misbranding and adulteration in mind. Antiseptic, this is the representation of a drug, device, or cosmetic and its labeling as an antiseptic shall be considered to be a representation that is a germicide, except in the case of a drug purporting to be or represented as an antiseptic for inhibitory use as a wet dressing, ointment, dusting powder, or other such use as involves with the prolonged contact with the body. New drug means, and again we talked about this with the federal law, any drug not generally recognized among experts qualified by scientific training and experience to evaluate the safety and effectiveness of drugs as safe and effective for use under conditions prescribed, recommended, or suggested by the drug's labeling, except that such drug, a drug not so recognized, shall be deemed to be a new drug if at any time prior to September 1st, 1939, it was subject to the former Federal Food, Drug, and Cosmetic Act of June 30th, 1906, as amended with the Pure Food and Drug Act, and if at such times its labeling contained the same representations concerning the condition of its use. New drug also means any drug, the composition of which is such that the drug, as a result of investigations to determine its safety and effectiveness for use under such conditions, has become recognized, but which has not otherwise than is such investigations been used to a material extent for a material time under such conditions. Now, that last statement is a result of investigations, so that means not one investigation, but two or more. Device means instruments, apparatus, or contrivances, including their components, parts, and accessories intended for the use in the diagnosis, cure, mitigation, treatment, or prevention of disease in man or animals, or to affect the structure of any function of the body of man or animals. The term Federal Food, Drug, and Cosmetic Act means the Federal Food, Drug, and Cosmetic Act of the United States of America, approved June 25, 1938, officially cited as public document number 777, 5th Congress, Chapter 675, 3rd Session, and its amendments now are or hereafter enacted. Again, that goes back to the Federal Food, Drug, and Cosmetic Act. Wholesaler means a person who bottles, packs, or purchases drugs, devices, or cosmetics for the purpose of selling or reselling to pharmacies or to other channels as provided in this article. And an advertisement means all representations disseminated in any manner or by any means other than labeling for the purpose of inducing or which are likely to induce directly or indirectly, the purchase of drugs, devices, or cosmetics. Controlled substance means any drug defined as a controlled substance by Article 33 of the Public Health Law. Manufacturer means a person who compounds, mixes, prepares, produces, or bottles or packs drugs, cosmetics, or devices for the purpose of distributing or selling to pharmacies or to other channels of distribution. Now keep in mind, it's also probably important to point out the distinction between what a pharmacist does and what a manufacturer does. As you get into your third year and you talk about this more completely, pharmacists are allowed to compound certain amounts when they, in the normal course of business, they know that patients will be coming in and they will use it in a finite amount of time. Whereas a manufacturer, the distinction is that they make so much that they can't possibly take care of be using it in a finite amount of time. They would actually give it to somebody else to sell. So there is a distinction, but there are some pharmacists who become manufacturers and they need to be licensed as a manufacturer, not just as a pharmacist. So keep that distinction in mind. Administer for the purpose of Section 6801 of this article means that the direct application of an immunizing agent to adults, whether by injection, ingestion, or other means pursuant to a patient-specific order or non-patient-specific regime prescribed or ordered issued by a physician or a certified nurse practitioner who has a practice site in the country in which immunization is administered. However, if the county where the immunization is to be administered has a population of 75,000 or less, then a licensed physician or certified nurse practitioner may be in an adjoining county. Such administration shall be limited to immunizing agents to prevent influenza or pneumococcal disease and medications required for emergency treatment of anaphylaxis. Again, this has a sunset provision. Basically, what all that means is you should keep in mind until fairly recently, most healthcare practitioners thought of prescribing by the physician, administering by a nurse, and dispensing by a pharmacist, and there is some fuzziness now between those distinctions. Now we're saying that a pharmacist can administer certain things like an influenza vaccine, a pneumococcal vaccine, or some kind of a drug for anaphylaxis if that person has a non-specific